Hi.
Hi.
I don't have to be quiet.
Oh, it's 8 questions?
Do you have them?
Yeah, I took a picture of it. I just noticed it today.
Te los imprimí. Hi, Anna. How are you?
Hello, good. How are you?
Good. Hi, everyone who's joining. We are going to be doing a webinar with our youth leaders here at Juntos and with CLS Philly. And maybe we'll wait a few minutes for a few folks to join us. A few more folks.
Hello.
Hi, Laura.
How are you?
Good. I want to introduce you to Maritza. This is one of our youth leaders.
Hi. How are you? What's your name again?
Marissa.
Maritza. Hi, Maritza.
Oh.
one more is coming right now.
Okay.
And this is Edgar.
Hola, buenas.
Hi, Edgar. Nice to meet you.
You too.
Edgar. Hi, everyone who's joining us. We're going to be starting a Know Your Rights webinar for youth workers in a little bit. We're here with Community Legal Services and some of our Fuerza youth leaders. Just want to add one more presenter on here. Can you show me how to do it? Oh, yes. Great. That's why we have the youth leaders here. She left. Corbrina. Great. Okay, I just sent the other request. Just gonna wait for one more person. Cool. I shared the request with Core. It's just saying that we're waiting for you to join and to accept the request. Oh, she's unable to join. Let's see, try one more time. Hi, everyone who's joining us. We're just adding one more presenter to our live, and then we will get started.
I think Cora's going to try to leave and then rejoin.
Great. Okay. Cancel that request.
Maybe we can just start explaining what we're going to do so that people don't jump off.
Sounds good.
Yeah. So hi, everyone. My name is Laura Rodriguez. I am here today with my colleague, Rhiannon. She's an attorney. I'm a paralegal. We both work at Community Legal Services. We are a nonprofit organization in Philadelphia who provides legal assistance to Philadelphians. And Rhiannon is gonna explain a little bit more of what we do and what we can help with. Thank you, Juntos, for inviting us today to talk about labor laws. that's specifically concerned to youth members and leaders and workers. So yeah, we're excited. And yeah, let's see who else is going to be joining us and if Cora can log in.
Yeah. Cora, I sent the request over. It just says that we're waiting for you to accept it.
So the way that this conversation is going to go is that we are going to first have a small introduction, then we are going to be explaining overviews about the topics that we're going to be touching on today. And then your youth members are going to be asking us interesting and important questions, and then we're going to leave space for additional questions at the end if the audience joining us wants to drop any questions in the comment section. And you can do that throughout the presentation if you want if you want us to elaborate more on any of our answers. Please feel free to leave your questions in the comments.
Thank you, Laura. I'm going to try to resend the request to Cora one more time.
Maybe, Cora, I don't know if you can on your end request to be in the live video.
We're just everyone who's joining us, we're just waiting for a youth leader from CLS to be able to join the live with us. Oh, okay. Oh.
All right, well, if it's not working, I can do a plug for YJP on Cora's behalf.
Yeah, if for some reason she's able to join at the end, maybe we can have some space for her to.
Great.
All right, Cora. So Cora works in our Youth Justice Project, and we were hoping to have her here today to talk to you all about Community Legal Services Youth Justice Project, which connects young people ages 16 to 24 to free legal help at Community Legal Services, and also our sister organization, Philadelphia Legal Assistance. So the Youth Justice Project helps with criminal and juvenile records, family and kids, public benefits, housing, as well as debt. So a variety of different legal issues. If you are between the ages of 16 and 24 and are looking for legal help, you can go to our website, clsphila.org, and under our projects page, you'll find the Youth Justice Project, where there is a virtual intake form that you can fill out and provide some basic information, and someone from CLS will follow up with you. But since we're talking to youth leaders today at Juntos, we just thought it'd be a good opportunity to connect young people with our Youth Justice Project at CLS. But as Laura mentioned earlier, we work in the employment unit at CLS, Community Legal Services, and our organization provides free legal resources and legal assistance to residents of Philadelphia. So we work in the employment unit, and we are typically, our day-to-day is helping folks with employment issues ranging from wage theft to workplace discrimination. And now during the pandemic, helping folks figure out whether they're entitled to paid sick leave, different health and safety questions about returning to work and working safely during the pandemic, and as well as unemployment benefits and PUA. But today we're just going to do a brief overview of some of the basic worker protections here in Philadelphia, specifically related to young people. So our hope is to just give you kind of a brief, very high level overview of some of these worker protections. And then we'll do a Q&A at the end. And as Laura mentioned, if you have any questions, feel free to drop them in the chat, and we'll try and address them as best we can. So I'm going to turn it over to Laura to give a brief overview of some of the child labor laws here in Pennsylvania.
Okay. Thanks, Rhiannon. So yeah, we're excited to be here. We hope you have many questions, and this is also something new for us. This is a topic that obviously concerns us, and we represent regularly workers in Philadelphia and people who also work in another state but live in Philadelphia, like New Jersey or like the vicinities. So yeah, there's child labor laws under federal and state. We're going to be talking about the state ones today because they are the ones that are more strict. So that's the first thing that you need to learn, that when there are several regulations within federal, state, and local levels, you usually have to go with the one that protects you the most, or like that grants you more rights. So, for example, for Pennsylvania, one of the first things that is important to highlight is that the child labor laws usually just lists what youth workers cannot do. For example, and it explains the restrictions within schedules or hours a day that a youth worker can work. For example, for 14 and 15-year-olds, they can only work during school terms 3 hours a day, 18 hours a week, and then that can be extended for a couple hours after school when the school is not in session. Another important thing that also is different when it's for 16 or 17-year-olds. They can work a little bit longer. It's not more than 8 hours a day or more than 20 hours a week during school term. And again, that can be extended. I think it's up to 40 hours a week or 48 hours a week when the school is not in session. You need to work within specific hours. For example, for 14 and 15-year-olds, you cannot work before 7 a.m. or after 7 p.m. That can be extended on vacations. You can work, I think, until 9 p.m. And for people who are 16 or 17-year-olds, you can work from 6 a.m. to 12 p.m. Another important thing to note here is that your employer needs to give you breaks, lunch breaks. They have to give you at least 30-minute breaks each day. And you cannot work, as a youth worker, you cannot work more than 6 consecutive days a week. So you should have at least 1 day off per week. And obviously this law, it protects people who are younger than 18 years old. So by the time you reach 18 years, you are protected under the regular labor laws that are just cover the rest of the workers in the state. And so, as some of you may already know, in order for you to join the workforce, you need to apply for a work certificate. We're going to be elaborating more on that later, but it's just basically something that needs to be considered when you want to be an employee in Pennsylvania. Some other states require you to prove that you are, what your age is if you want to work, but in Pennsylvania, the requirement is a certificate that needs to be issued to you. And so now I'm going to pass it to my coworker, Rhiannon, so that she can explain to you some highlights about wage law.
Thanks, Laura. So I guess if you guys can write in the comments, does everyone know what the minimum wage in Pennsylvania is? Let's see if we get any takers.
$7.50.
I heard someone.
Oh, I said $7.50.
Close. So in Pennsylvania, it's tied to the federal minimum wage, which is currently $7.25 an hour. So all workers, regardless of your age, need to earn the minimum wage, which is $7.25 per hour. And this applies regardless of how you're paid. So if you're being paid under the table in cash, if you're being issued a check, if you're getting direct deposit, your pay should be $7.25 at a minimum. There's limited exceptions under the law as to when employers can pay you less than $7.25. So if you're working in a restaurant as a server and you're getting tips, tipped employees can be paid a lower wage, which is $2.83 per hour, plus your tips. And you know, if you look at the average of your wages, the $2.83 per hour and tips, if it comes out to less than $7.25 an hour, your employer should be making up that difference. There are certain occupations that aren't covered by these laws, but it's really specific, and I don't want to bog you guys down with that now, but generally $7.25 per hour. And if you're working more than 40 hours a week, you are entitled to overtime at 1.5 times your regular rate. So if you're making minimum wage and you're working 44 hours a week, so 4 hours should then be paid at your overtime rate, which would be $10.88. If your employer is paying you more than minimum wage, so if they're paying you $10 an hour, then your overtime rate would be 1.5 times whatever your promised wage is. So in that case, it would be $15 an hour for overtime. Your employer, another thing to know is that your employer should be giving you a pay statement with your pay. So you should be getting a pay statement every week that shows the hours that you worked. It should show what your rate of pay is, whether there's any overtime on your pay, and what your gross pay is. So one thing we find a lot of times is when folks come to us with wage issues is that, you know, their employer hasn't given them any records. They're very concerned that they don't have any evidence to prove, you know, what hours they worked, what they were paid, especially when people are paid in cash. So, you know, if you're not getting a pay statement from your employer, that's one thing that you should definitely ask for if you feel comfortable doing so. But if not, we always recommend that people keep their own notes, keep a little notebook, write down what your hours were, when you were paid, how much it was. So you have a record of all of that in case things go south. And generally, the other thing I like to mention is that employers are not allowed to deduct anything from your wages other than the normal stuff like payroll taxes, your income taxes, without your permission. So sometimes we see people that come in and their employers say, well, you know, they were working and they broke the stove, so I took it out of their pay. They are not allowed to do that. And really, generally, there's not many reasons that employers should be taking things out of your pay, even with your consent. So that's just something to know in case you see any weird deductions on your pay stubs, don't know what they're for. That's wage theft. So if you are getting paid less than minimum wage, if your employer isn't paying you on time, if they're not paying you for all of the hours that you worked, this is all wage theft under Pennsylvania and federal law. And here in Philadelphia as well, we have a wage theft ordinance. So if that's happening to you, you can always come to CLS, and we can give you advice about your legal rights and whether you need to file a complaint with the city wage theft office, or, you know, sometimes even in court if you're owed a lot of wages. So that's something we definitely help with. And the other thing I like to note is that under the wage laws, if you make a complaint about your wages, you're protected against retaliation. So if your employer, you know, you complain, you didn't pay me for all of my hours, and they say, well, you know what, you can just leave, you're fired. That's retaliation, and that's illegal under the law. So then you have additional legal claims and you can get additional damages under the law. So, you know, if you are afraid that your employer might retaliate against you, or they do retaliate against you, that's definitely something that we help people kind of figure out how to handle, and help pursue legal claims. So that's your very quick and dirty overview of wage theft here in Pennsylvania. I'm going to turn it back to Laura to talk a little bit about employment discrimination.
Sure. So yeah, employment discrimination is another of the categories of labor laws. The anti-discrimination laws, there are laws at all the levels. This means state, federal, and local law. What this does is protect you against illegal treatment and unfavorable treatment by your employer. And I emphasize illegal because there might be instances when your employer is not treating you right, but it might not be necessarily considered illegal. So the law protects people who are members of a protected class, which means generally you are protected if based on your sex, religion, national origin, your race, and there are other additional extensions, and it's more broad, the protections under state and local law. There's also age discrimination. We're going to also be explaining more about it later. But yeah, so the law says that you cannot be treated differently, that you cannot be for example, the employer cannot refuse to hire you or promote you or say that they are going to pay you less because of your race, your sexual preference, or any of the categories that are considered protected class. Another obligation that the employer has is to, if you complain about it in the workplace, they need to follow up on your complaint. Whether if it's like an internal process that you have in your employee handbook, or just something that they instructed you to do at the beginning of your employment, you should follow that protocol, or at least if there's no protocol in place, make your manager or any supervisor aware of it, and they need to investigate and try to resolve the situation. If there are instances when the harasser or the person who is discriminated against you is the manager or the person in charge, then you should still try to do it or like make your place of employment aware with a coworker or probably another person that is not directly supervising you, or again, come to us for legal advice and assistance, and we can help you file with different government agencies. There are government agencies that specifically receive these types of complaints at all levels. You don't need attorneys for these type of complaints, but you do need to keep in mind that there are very sensitive deadlines that you have to meet in order for your complaint to go through and not be valid, but yeah, so that you don't miss any deadline. We're not gonna get into all that process right now, but yeah, it's usually, there are times that need to be met that start counting the deadline since the time when the adverse action happened against you. So yeah, it's just important for you to know. We see instances also that there's harassment at the workplace, and it is important for people to understand that harassment is a way of discrimination. And again, it has to be under the categories that we have previously mentioned. So just please be mindful about seeking advice or assistance, or at least we're going to be providing different resources during the presentation and providing the links for you to get more thorough information about it. But if you are not sure whether it falls under a violation of the law, still seek advice instead of just assuming that it doesn't, so that you can your case can be properly assessed and you can get the direction that you need to take proper action. So I guess that's it. Oh, yeah. The one other thing that I wanted to mention is that it is important for people to understand too that discrimination, harassment, and these violations of the law at the workplace don't always have to come only from the people at your workplace. It's common that it comes from coworkers, from supervisors, from people in a position of power, but it can also come from clients. It can also come from customers. It can also come from people who come to deliver things at your workplace, like, I don't know, the package delivery guy or something like that. So it's important for you to know that you are still protected under the law if you suffered from discrimination of harassment from people that are not directly employed at your workplace or are not in a supervisory position in there.
Thanks, Laura. And just like the wage theft laws, the anti-discrimination laws also prohibit retaliation and apply to all employees, regardless of your immigration status. So I also want to just talk briefly about health and safety in the workplace, because this is a big concern right now with the pandemic, with people who are either essential workers continuing to work throughout the pandemic or are now being called back to work as things are opening up. So generally, even when the pandemic's not going on, there is a federal law called what we call OSHA, it's the Occupational Safety and Health Act, that protects workers in the workplace. And it basically creates a duty on the employer to create a healthy and safe workplace. So OSHA is a federal agency. We don't have kind of a designated state agency here in Pennsylvania that has a similar kind of motive. But so workers who are concerned about health and safety violations in their workplace do have the right to file complaints with OSHA. What OSHA does is they send in an investigator, generally to do an investigation to find out whether there's any sort of shortcomings in the workplace. And there are whistleblower protections under OSHA. Now, what we've seen during the pandemic is that OSHA has been completely ineffective at addressing health and safety issues in workplaces. They've gotten tens of thousands of complaints and just haven't investigated them. So, you know, unless there's some serious kind of health and safety violation going on at the workplace, OSHA might not be the best avenue to take a complaint. What we generally at CLS recommend is, you know, if there is something of concern at the workplace with regards to health and safety, trying to get together with your coworkers and make a demand to your employer. So, you know, it could be, you know, we request A, B, and C changes in the workplace so that we can feel safe. Because there's actually another federal law that protects workers who engage in what we call concerted protected activity. So this is essentially, you know, if you and a coworker get together and go to your boss and demand better working conditions, you are protected under the federal, it's called the National Labor Relations Act, against retaliation. So if you go and raise concerns about health and safety to your employer, either speaking on behalf of other coworkers, or you do it together as a group. It could be writing a letter, an anonymous, even email we've helped people do. If you do that, you know, request something as a group together related to your working conditions, then you are protected against retaliation. And the National Labor Relations Act actually has much better enforcement mechanisms. So if you are retaliated against, you can file a complaint with a federal agency that does very good investigations and can issue back pay if you're fired, reinstatement to your job, and you know they'll make employers put like posters up about like workers' rights, about, you know, organizing and things like that. You don't have to be in a union also to be protected. Any sort of kind of group organizing is protected under federal law. And specifically with regards to COVID, now there are state requirements right now, health and safety requirements for businesses that are still in effect, even though things are opening up. So businesses have to continue to follow these health and safety requirements from the state. Philadelphia, the city, has gone ahead and passed a ordinance that basically protects workers who complain about health and safety violations against retaliation, specifically related to COVID-19 safety regulations. So if your employer is not following the state's social distancing mandates, if they're not, if there are mask mandates in place for customers and your employer is not following them, what you would need to do is make a complaint. There's different ways you can do this. You can call 311. There's an online complaint form with the State Department of Health. Or you could just make a complaint directly to your employer, either you yourself or even better as a group, because then you have additional protections. If the employer retaliates against you, then you can go to the city and file a complaint, and the city will actually investigate and can order penalties, reinstatement, back pay. So while the federal protections aren't great, there are some other protections in place that can help workers who are concerned about health and safety, and especially right now during COVID when people are being called back to work. So again, you know, these issues are all kind of complicated and it's kind of hard to try and figure out things on your own. So if there's anything going on at your workplace that you have questions about or want legal advice, or even, you know, you're thinking about organizing and you want to connect with an organization here in Philadelphia that helps workers organize their workplaces, you can always reach out to CLS and we may be able to give you legal advice or take on your legal case or refer you to another organization or agency that might be able to help you. So like I said, that was really a quick and dirty overview of everything. So I think we're going to turn to some Q&A right now from some of the youth leaders at Juntos.
Introduce yourself first. Hello, my name is Maritza.
Hello, my name is Edgar.
Hi, Edgar. Hi, Marisa.
Hello. One of the questions are, I want to get a job, but I'm under 18. How do I get a work permit?
Yeah, so generally speaking, you have to apply for the work permit at the school district where you're going to be working. For example, if you work in a school district here in Philadelphia, but you're going to work, I don't know, in a suburb in Pennsylvania, or you're going to work in New Jersey, then you have to apply for the work permit at the school district where your employer is located. You do not have to have a job offer in order for you to apply for a work permit. You do still need to meet the requirements to apply for a work certificate. Now, before it used to be that you have to go in person to the issuing officer at a specific building at the school district for them to issue it to you. You will have to sign it in the presence of the issuing officer and all of that. Right now, obviously, because of COVID, these requirements, the in-person requirement has been waived, but you still need to provide the supporting documentation, and it can be either electronically or by mail. But yeah, I will be dropping in the comments the link for the education department website so that you can visit there and see a more comprehensive list of requirements and all the steps that you have to follow for anyone who's interested in getting a work permit.
Thank you.
So the second question we have is, are different wages legal for youth versus adults if they do the same job?
Unfortunately, the answer is yes, which seems crazy. But as Laura mentioned, right, there are anti-discrimination laws that prohibit employers from treating workers differently based on protected classes. Now, age is actually a protected class, but under federal and Pennsylvania law, when they talk about age, they are specifically talking about older workers. So workers over 40 cannot be treated worse than younger workers. And there isn't some sort of kind of reverse discrimination claim for younger workers. So employers can pay people different rates for doing the same job. It's not necessarily a legal violation, but if they're paying you a different rate based on some other protected category, so race, religion, national origin, sexual orientation, gender identity, you might have a legal claim. But unfortunately, under Pennsylvania, this age discrimination protections are only really protecting older workers from being treated less well. But again, if there are other younger workers and maybe there could be some sort of organizing campaign or some demands that you could make together on the employer to get more parity between pay. And again, I guess I would just plug that you should be making the minimum wage. They shouldn't be paying you less than $7.25 an hour, and overtime if you're working more than 40 hours a week.
I work under the table, and I sometimes don't get paid for all of my hours. But the manager says he'll pay me in a full later. Can I try get my missing payback even though I work under the table?
I'm going to repeat your question to make sure I got it correctly, just because the audio was a little bit choppy and I want to make sure people heard the question. So your question was, you work under the table, sometimes you do not get paid for all the hours by your employer or your manager. They say they're going to pay you later, and you want to know if you can get those wages, and even if you work under the table. So the short answer is yes. As Rhiannon had previously explained, the law requires the employer to pay you at least minimum wage. And under Pennsylvania law, the employer is required to pay you your promised wage. If that's higher, they have to go with the higher number. Even if they told you at the beginning, oh yeah, I'm gonna pay you 15 or 10, and then later when you started, they were like, oh no, actually just 12. They promised it to you so you can pursue that additional difference that they are not giving you. The law also says that they need obviously to pay you for all hours worked. And we see many instances of clients that they work more than 40 hours a week, and the employer is not keeping good track of the hours. And they are just like, oh yeah, your schedule is going to be from 8 a.m. to 5 p.m. But in reality, they are working more than that. And they are just promised a flat rate, or they are being paid by the day or by the week. regardless of how you get paid, you do need to get paid for all your hours worked. They cannot tell you like, oh no, you are not entitled to overtime because I paid you per day or per week. We can still help you make the calculations for that. But yeah, and also another important thing to mention here is that there's a 3-year statute of limitations or a deadline for you to pursue action if you have missed wages from your employer, whether if it's your current employer or your any former employer that you have. If you had an instance or you work at a place that didn't pay you in 2019, you can still probably pursue that claim and try to recover your wages. We often recommend don't wait until the last part of the deadline. Try to do it as soon as possible. And as Rihanna mentioned before too, keep records. It's not the requirement for you under the law, but it's really, really helpful because in that way, again, as I mentioned earlier, even if you sometimes are told one thing, the employer, if they start paying you late, if they start not paying you all your hours, that's a sign that they are going to continue doing it. So that's a sign for you to actually start being very diligent about keeping your own records, because chances are in the future you are going to need those records. And obviously, we're not expecting anyone to have every single date and hour or have a good recollection of what schedule did they have for the past year. So that's why it's important for you to keep everything in writing, because in that way you can always, if in the future you want to take legal action, you can always refer to those documents that you have. And now, since we all have smartphones, you can always just make a note on your cell phone or take a picture of your schedule, take a picture of your check, however you're paid. It doesn't have to be anything formal. Even it can be a text that you send to one of your friends, like, oh yeah, I just got to work, or I just left work. Anything that is a digital record for you to be able to have that tracking of your documentation so that you can use it in the future if needed. Give me 1 second. I think we lost one of our guests.
Yeah. I'll add her back in.
Okay.
Yeah.
Okay, I think she had issues with her phone.
Yeah.
So let me just, maybe we can just wait, well, yeah, let's continue. Hold on 1 second.
Okay.
Okay, yeah, I guess yeah, I don't want everyone waiting here. So yeah, we can just continue, and hopefully she will be able to join us again soon.
Okay. So the next question we have is, how can I make sure my work environment is safe, and is there any basic protections that exist?
I feel like this is not the best answer, but yeah, there are protections. They are called health and safety regulations, and that's under the OSHA law that Rhiannon previously mentioned. And so the way that it works is that OSHA says that your employer is required to provide you with a safe space, free of hazards, any recognized hazards, and provide you with the proper equipment if you are going to be working in a place that you can get hurt. And especially under child labor laws, the most important thing is to protect your well-being and your health, to make sure that not any type of work that you do will interfere with your health or with your ability to continue being in school. So yeah, for example, for as I mentioned before, the state law has regulations that say that there are specific work or job restrictions and types of employment that you cannot have. For example, you cannot be working in manufacturing jobs. You cannot be a driver if you are, I believe it's under 16 or 17. You cannot be in positions that require you, for example, pizza delivery driver. You cannot do that because there are like very sensitive deadlines to meet when you are on those type of jobs. So in general, it's more like restrictions that apply to your specific place of employment. Hi, Rihanna. Thank you for joining us again.
Sorry, guys. My phone overheated in the middle of it.
I was just going over the question that says, how can I make sure my work environment is safe? And I was just explaining to them that there's OSHA regulations that, as you mentioned before, they are not the best. That OSHA says that they are required to, the employer is required to provide them with a safe space free of recognized hazards. And also the child labor law says that there are restrictions of the type of work they can do, no manufacturing, no handling heavy machinery and things like that. But there's not, I feel it's not the best answer. I'll drop in the comments the links for the resources on the OSHA website, but I don't know if you can add, if you want to add anything else.
No, I would just say again that with health and safety stuff, you know, I think organizing can be a great tool. If you can get your coworkers on board, you can put together a list of demands that you want to improve your workplace. And like I mentioned before, you know, when you act together as a group to demand better terms of employment or working conditions, you are protected under federal law against retaliation. So there are a bunch of organizations here in Philadelphia that can help workers who want to organize and demand better workplaces that we are happy to connect you with if that's something you're interested in. We can also help people, you know, if you want to put together some written demands to your employer or create a ghost email account that you can use to send some sort of demand to the employer so that you are not kind of singling yourself out or other workers for retaliation. Those are the types of things that CLS can help with. But when it comes to health and safety, I think that's kind of one of the fastest ways that you can get employers to change their practices.
Yeah, thank you.
I work in a restaurant and the exhaust fan has been broke for a long time. Sometimes it gets so smoky in our restaurant that the alarm goes off and we had to stand outside until it airs out. And then we go back in. What are my options?
This ties, I think, a lot into the last question. While there might be some sort of complaint you could make here, because it's just this broken exhaust fan that needs to be fixed and the employer is not doing it, probably some sort of organizing would be helpful to try and get this fixed more quickly. You know, I think it might not be necessarily a straightforward legal claim, but by putting pressure on the employer, right, if the employees say, well, we're not going to work until this fan is fixed, it might encourage the employer to fix it more quickly. So, right, that's again like a type of organizing campaign that you could do with your coworkers. And if you're working, it sounds like maybe it's a restaurant. But like I mentioned before, you know, if this is something that in your workplace, there's a lot of kind of issues that you're being faced with on a day-to-day basis in your job, there's organizations like the Restaurant Opportunities Center, 1PA, different orgs that help workers organize and come up with ways to improve their working conditions. But that just sounds horrible.
Because generally speaking, the employer has the right, I mean, the obligation to make sure that everything in the workplace is working correctly. So it seems if this is happening more than one time, it's something that the employer has not been taking care of, instead of just like one accident or like an unusual thing.
Yeah.
Okay. The next question. My job doesn't social distancing guidelines. I'm immunocompromised members in my family and want to keep them safe, but I don't want my job to file concerns. Can I report this anonymously?
Can you repeat your question again, because I missed some part of it, like the audio was not clear.
Okay. So my job doesn't uphold social distancing guidelines. And I have immunocompromised members in my family. And I want to report it, but I don't want to get fired for raising concerns. Is there any way to report this anonymously?
Yes, and it depends. So, for example, there are different regulations or government agencies that you can approach. First of all, the state requirements and COVID guidelines are still in place, even if people are getting vaccinated and even if some restrictions are being lifted. So your employer is generally still required to ask you to wear a mask in a closed space, make sure that there's like the 6 feet distance between people or tables or wherever you work, to promote, staggering shifts or something like that to prevent crowded spaces at the workplace. So all those type of regulations that we've been hearing about for the past year are still in place. So that's things that they have to comply with. Another important thing is that, yes, there are ways to make the complaint anonymously. You can do that through the Department of Health, Pennsylvania Department of Health website. Actually, it's a very simple form to fill out. You can do it online, and when you enter the website, it just gives you one of the first boxes. It says, I want to file this anonymously. However, we don't know how well they follow up on complaints that are filed anonymously. But yeah, there's still a resource that you can use. And again, in any of these laws, you are protected from retaliation if you file this type of complaints. And also, there's local resources that you can call 311 if you, not only as an employee, you can do that as a patron in any place that you are seeing the guidelines are not being followed. But most importantly, last year, there was a local law that went into effect to specifically address this type of issues. It is called Essential Workers Protection Act. And it basically, what it does is provides the worker with protection in case that they want to raise concerns to the employer about COVID-related issues that they are seeing at the workplace, or they want to refuse unsafe work because the employer is not doing anything about those concerns that the employee is raising. So what the law says is that you can bring the concerns to your supervisor and they have to act on it. You can, for example, alert the Department of Health or make that an inspection happens at your workplace to make sure that they are in compliance with the guidelines. And even if it's determined that there's no violation of the guidelines and that they are doing their job correctly, you still cannot be retaliated against. They cannot take adverse action against you. They cannot be like, oh, now I'm going to fire you, or I'm going to put you on this different schedule that doesn't work for you, or I'm going to lower your wage. They cannot do that. And if they don't take action, then you can refuse an unsafe work. Let's say that you work at a customer service position that you are, or at a restaurant where you are seeing that no distance guidelines are being followed, and you tell to your supervisor or employer, I don't want to do this, I don't feel safe, my family is immunocompromised, they possibly could give you the option to do another type of job that doesn't require you to be exposed to as many people, or that prevents you from being exposed to COVID, most of all. So if they do that, then you cannot refuse that offer. So you will have to accept it. If you refuse it, even if they gave you a safer option, then the law will not apply to you. But if they don't give you that option and neither they comply with the guidelines, and it ends up being true that there are violations, then there's an investigation that needs to happen, and then you are protected against retaliation. and the law is still into effect. So the Department of Labor website, they are in charge of enforcing, I think it's about 9 different labor laws in between Essential Workers Protection Act, wage laws, sick leave, and many other ones. So the complaint is really easy to file. We help people with these issues. And even if this law doesn't apply to you, because of course we understand not all people are working in Philadelphia, then you still have protections under the National Labor Relations Act, which I think Rhiannon had mentioned before. Is just basically joining a protected concerted activity, meaning that you can talk to your coworkers and say, I don't feel safe, what are we gonna do about this? And come to your employer as a group. And I emphasize group because it's a requirement under the the federal law. It doesn't mean that if you come to your employer by yourself, you are not going to be protected, but it's a little bit more difficult.
I would actually, Laura, go even further and say it just has to be you and one other person. It's just more than you. And you can even go alone and be speaking on behalf of other workers. So, you know, if there was a Facebook page and you were a worker and you posted, you know, me and other workers have complained about, you know, our employer not following social distancing guidelines and they're putting us at risk. That would actually maybe protected concerted activity under the law because you are raising a concern about your working conditions and speaking on behalf of a group.
So yeah, and that's another thing, another important thing to note in comparison to the local law. The local law just doesn't say anything about having to be 2 or more. It can be just you, and you will still be protected. And yeah, so we can also help you to draft. You don't even have to do it in person. You can just create an email account and raise the concerns and send it to the email to your supervisor, employer email, so that they don't identify you and then target you. And then if you are fearing retaliation, because we do understand and know that that's an important issue for most people who are experiencing violations of the law at the workplace.
Someone in the comments said, would filing anonymous complaints by many workers have a more beneficial impact on our rights being addressed? Probably. I mean, we haven't seen really how this has played out, but my guess is if a bunch of people went on and filed a complaint about the same employer on the Department of Health website, or a bunch of people called 311 and made a complaint about the same employer, it would raise red flags and maybe motivate the state to look into it more quickly or take it more seriously. So I think, you know, to the extent that there are a few people that want to file complaints, I think that would definitely help. But, you know, also if there are many workers, again, you could try and raise it as a group directly with the employer and be protected. If folks have, do you guys have, does Juntos have any more questions, or we?
Feel free to share your questions in the comment section.
My manager regularly harshes me and singles me out because of my age, but I don't want to lose my job. What are my options?
So this is a hard question because, like I mentioned before, even though the anti-discrimination laws prohibit discrimination based on age, when you look more closely, those laws are specifically protecting older workers. So it's not clear to me, you know, if a manager was just singling someone out because of the fact that they were a younger worker, whether you would have some sort of legal claim to pursue. You know, it's also not right for the employer to kind of be harassing you, even if it's not on a protected category, right? Some employers have in place anti-harassment policies that are more broad than what the law says. Any way to make a complaint. And And if not, it's still something that you might want to try and consider raising either with another manager you trust, or, someone that's a supervisor in a higher position that you feel comfortable going to see if there's some way to address it with the manager that is doing this. But again, that's something, that CLS is happy to help people kind of figure out whether there's a legal violation, and, what their next steps might be.
Okay. So this is our last question. Are there ways to see if an employer has a bad record?
We wish there were better ways, but the short answer is not really. I mean, for example, the Philadelphia Department of Labor does have what they call a bad actors list, which is generally just a technique that they use to try to get the employers that have received complaints to comply with the law, to make them pay for the wages that they owe to employees. But, for example, the employers that make that list are not everyone. It's just employers who refuse to follow up with the Department of Labor or refuse to comply with the determination that the Department of Labor in Philadelphia issued. But that doesn't include employers who also had complaints and who eventually ended up complying with the law. So that's a flaw to some extent, because it's not an inclusive and broad list of the employers that have violated the law. There's also another similar list with OSHA. But again, first of all, those lists are not easy access to everyone. It's not like you can just Google bad actors list and find it easily on website on Google. So yeah, that's difficult. Again, there's no good answer for this, but to some extent, what we could suggest is just make a Google search about a prospective employer. There are different platforms that share job positions available in places. So you can just, I've seen it before, that some people who previously worked there share their experiences and the pros and cons and the type of wages that they receive. So yeah, for now, that's the only resource that it's available. Rhiannon and I were talking that would be a good idea to have like a database of all the employers who have not complied with the law. But yeah, for now, it's just that.
Unfortunately, what we see a lot of times with bad employers is that, they settle a claim with a worker, right? So before a case would go to litigation or end up in court, they enter some sort of agreement to pay a worker. And a lot of times what they'll try and do is get workers to sign, confidentiality agreements that prohibits them from talking about what happened to them. And this is one tool, one way in which employers can try and muzzle employees from talking about their bad experiences with them. And it's really unfortunate, because then it's much harder for people to learn about bad actors, or to just know, for people to be able to share their experiences and what happened to them at work. But yeah, unfortunately, we do not yet have a bad actor search database.
Mm-hmm. Thank you all. These are all really good questions. We are gonna just leave a couple minutes for people who are watching to see if they have any additional questions, or if any of you two want to ask anything else. Just questions, no questions.
We don't have any questions, but maybe anyone in viewing can send us some questions if they have any.
Yeah, I don't see. Let me see. No, I don't see any questions here as of right now. Okay.
It's always hard to come up with questions on the spot.
Yeah. Look at us, just finishing right on time. But yeah, no, I mean, again, this was just a very broad general overview of your rights. We're not expecting you to remember all that we explained. Hopefully you will get the different links that we shared with Juntos so that they can that you can go over the flyers and posters and all the different resources available for you within the different government agencies. Always ask, there's no silly question. It's very important that every single worker, regardless of their age, understand their rights and are confident about enforcing them when there's a violation of the law, because Philadelphia has one of the more progressive laws, has passed very progressive laws within the past years. But it's not only about that, we need enforcement, we need action, we need to make employers compliant with these laws. Otherwise, the laws are just going to be sitting there. So yeah, please spread the word. Hopefully you learned something valuable today. And yeah, you will continue attending other trainings, and we regularly provide different types of trainings, not only on this topic, also state law, unemployment, many different areas that we don't cover, but different units in our organization cover. So yeah, I don't know if there's anything else that we should add.
I was just going to say, if you want more information, they have a bunch of resources on our website. It's www.clsphila.org. And, if you are experiencing issues in the workplace and need legal help or legal advice, CLS is open right now. And you can call our intake line. The number is 215-981-3700. And we will reach back out to you to follow up about your case. And just thank you, Juntos, for hosting us. We're very glad to be here with you today and be able to share this information.
Yeah.
Yay!
Thank you.
It's been really nice learning for you guys. So thank you so much.
Yeah. Thank you. Have a good one.
Bye,
Bye, everyone. Thank you for joining us.
Bye.
Okay. Just